front of you, I just want to give you a little bit of background that JD and I had discussed putting together just a question and answer session, which was really just an opportunity for those participating in the call to kind of just talk general issues about COVID. And well, that kind of then ballooned into, well, why don't I put together a couple slides where we can kind of have some jumping off points to talk about some subjects, to maybe raise some questions. And that's what the slides that we have. So I think the intention will be for us to, spend 20 minutes, half hour, kind of running through some general slides to kind of give you some general discussions and some topics, and then we'll get into more of the questions and answer on COVID. One of the other modifications that took place yesterday was JD and I had just discussed that I would be doing this, and I'm primarily the firm's Delaware lawyer, and I handle some of the matters out on the Eastern Shore. But JD had mentioned that a good portion of the folks that had signed up for today's seminar are from Maryland communities. And so as a result of that, poor Tiffany, who last night agreed to jump in and be available to handle primarily Maryland type questions, she agreed to do that. So Tiffany, thank you very much. And I don't know if you want to introduce yourself before we jump into the slides.
So good morning, or yes, still morning right now. Good morning, everyone. Again, thanks, Chad. This is Tiffany Releford from Whiteford Taylor Preston. As Chad said, I practice primarily in Maryland, D.C., and Virginia with regard to our community association clients, and I'm happy to be part of this presentation.
Excellent. Thanks, Tiffany. Okay, so here's where I thought that I would start out with on the slides. So Stephanie, if you could move us to the first slide. A lot of the questions that we're getting in the COVID as we now start to move into phase 1 and into phase 2 is really well, is this particular activity allowed? Should we open the pool? Should we open the clubhouse? And essentially what we've done with this presentation is we're going to get into all of those. So we're going to have a slide where we're going to talk about pools, and I'll try to focus the discussion on Delaware. Tiffany will add any of the nuances from Maryland. We'll talk about insurance. We're going to talk about clubhouse use. We're going to talk about the fitness center use, and then we're going to start to take some of your detailed questions. So I just want to remind everybody on the call, in this particular context, this is for general discussion purposes and for education. We're going to stay away from answering specific questions as to your community that might be construed as legal advice, because we don't want to give legal advice in this context, but we can talk generalities and go through examples. So anytime we're being asked on a question, whether it be the clubhouse or pool, should we reopen and when, we really are looking at two big broad categories of discussion points. And one is the activity allowed? And as we get into this seminar, I hope you won't be offended. I'm going to turn once in a while and look, because on the desk in front of me that you probably can't see from the screen, I have copies of the pool regulations. I have copies of the phase 1 opening regulations. I have copies of the Delaware corporate code, because each one of these is coming into play when we're being asked, can we do a particular activity? So that's the first question, which is, can we do it? And then if the answer to that is yes, based upon the regulations, then the question is, should we do it? And that's where we get to the second bullet point on this slide. And what we like to do is we like to give advice, legal advice to our communities to help them become better informed for making that decision. Because the decision of should you do it is a board decision. That's not for us lawyers to tell you. But what us lawyers are going to do is we're going to try to help you identify the risks. What are the additional risks? How can I manage those risks? What are my additional costs of compliance? What are the things I must do to comply? And once you as a board educate yourself on all of those things, you then weigh those risks and costs against the benefits of opening the pool. So for example, what's it going to cost me to comply with the cleaning regulations and the enforcement? Do I have to hire an employee? Is that a weekly charge? What are the additional cleaning components going to cost me? So put that into a number. There are additional risks. Now, if somebody contracts COVID at the pool, could you be sued? If you are sued, is there insurance? And these are the risks that you need to accumulate. So you put all of those things on your left hand, and then on the right hand, you weigh the benefits. Opening the pool has therapeutic benefits, or if we're in a resort type of community, it helps owners maybe rent out their property. So we have to weigh those costs and benefits and then make a decision. Are we going to reopen? Should we? And there is no right answer, right? So I've had a couple of communities call and say, should I open the pool? And my answer is, well, it depends. It's a community by community decision once you do an analysis of the risks and the costs and the benefits. So where we think the first thing we should talk about is insurance, because that is that risk management. And then we're going to, from there, go start to talk about cost compliance. So with that, if we could move to the next slide. And Tiffany, thank you very much for being willing to jump in on the insurance stuff.
So, as Chad said, we can't stress that second bullet point that was on the previous slide enough about whether or not the benefits and the costs outweigh, or whether or not the risks outweigh the benefits and the costs. So the one thing you want to think about is insurance is a huge aspect of all of this, and boards really need to be making conscientious decisions, keeping insurance in mind and when I say that, what I mean is you want to make decisions by which you're going to have the greatest extent of insurance coverage available if something should go wrong. So when we talk about insurance, there are generally two types. We're going to mention a third, but there are generally two types that you're going to be thinking about. The first is the directors and officers coverage, typically referred to as a D&O policy. The risk here, it's regulatory compliance, responses to authorities, operational adjustments. The coverage is typically, there are going to be some bodily injury and exclusions under this coverage. In addition, there could be invasion of privacy, things for disclosing if someone is a sick owner or something else. So you want to keep in mind what that coverage is. The critical issue with D&O is really that bodily injury exception, which again precludes coverage for claims based on an injury arising out of bodily injury. And I know that for the discussions I've had with a lot of boards with regard to the pool specifically and whether or not they should open the pool, one of the things we've talked about is even if an association were to prevail in one of these claims, if insurance isn't covering your defense of the claim, you are going to spend a lot of time and money defending a complaint, even though you may prevail in the end. So you also have to think about that. Yes, it's great when insurance coverage is available, but when it's not, there still may be a risk in that you're spending money that could be used for other things in defending a claim. The second type of insurance that we often are going to be thinking about is general liability coverage. That's going to be just your general policy. It's kind of like the catch-all bucket of all of the policies. Also, we kind of refer to it as property coverage. Most likely, this sort of coverage is not going to be available for COVID-19 related issues because it's going to be hard to prove, one, actual property damages as a result of COVID-19. Typically, you're going to be looking at bodily injury claims as a result of COVID-19. So you need to think about your pool and amenity. How do you minimize because you're going to probably have that injury exclusion. Your elevators and lobbies, what do you do to maximize potential coverage? Because that's one of those are two amenities that you can't say, we have to close down the elevators and everybody walks. You can't do that. So you're going to have to figure out what is the way that we can make sure that we're protecting people from transmission of the virus and using our elevators or coming through the common area lobby or other places. But typically that policy is not going to cover general bodily injury claims. So you need to keep that in mind, and you need to make sure that you're looking at that when you're thinking about these issues. The other thing to keep in mind is there's another policy, or it may be covered somewhere else, workers' compensation. Workers' compensation is one that we often only think about when it comes to our employees and whether or not they're going to be covered. This question came up early on for a lot of larger associations that do have staff that work on site. There were a lot of questions related to if your staff contracted COVID, would they be covered under a workers' compensation policy? Generally speaking, I can tell you the answer is no. Workers' comp ordinarily covers diseases that are unique to the employment itself, not to the ordinary general public. So when we think of workers' comp in the context of COVID-19, we're thinking about healthcare workers or also thinking about first responders, because those individuals are ordinarily going to face these types of situations where they're going to come in contact with people that may have some sort of highly transmissible virus or something else. But typically speaking, someone who works as a general manager or a maintenance person or something else is not in that line of work where they're typically going to be exposed to this type of an illness. So generally speaking, that if someone when your staff contracted COVID-19, usually not going to be covered by a workers' comp policy. So the main thing you need to be thinking about with regard to all three of these policies is, what can we do in order to make sure we have the greatest chance of insurance coverage should somebody file a claim? So that's another factor of that decision-making process with regard to the common elements and amenities.
All right, thanks, Tiffany. So the next slide that we have is where we're going to start to talk about, well, enforcement. Because before we start talking about the specific regulations for pools, what we want to talk about is the general enforcement once an association chooses to reopen one of its amenities, say the clubhouse or the pool. And where I'm pulling most of my guidance from when I'm answering these types of questions right now is coming from, first place is, for example, the Delaware reopening plan. I'll just show that on the screen. Maryland has a very similar plan. So I'm going to kind of generally talk about the analysis, how we go through it from Delaware's perspective. And then I don't think there's really anything much different from Maryland, but if Tiffany, if you're aware of it, just feel free to chime in. So the way that these regulations are set up, Delaware is now in phase 1, so is Maryland, right? Maryland's in phase 1. Delaware announced yesterday that phase 2 will start June 15th, so 2 weeks from the beginning of this week, we'll go into phase 2, and some of the things will change. So right now, phase 1. And the way that the guidance is developed in phase 1 is there's general guidance for individuals, there is general guidance if you're a business, and then there are industry-specific guidance. And each one of those, I think, is applicable to a community association choosing to open. For example, the general guidance leads to all people interacting with each other, and it covers things such as the face covering, washing your hands, the 6-foot distancing, the percentage limitations, the things that everyone's been talking about in the news and you've been hearing about. But when you go beyond the general individual guidance, you get to business guidance. And some of the things in the business guidance will apply to community associations. For example, certain common areas where people would congregate are typically to be closed. People are required to self-quarantine if they have certain symptoms. And these are the types of things that I think would apply to a community association that runs like a business. So if you have employees, the provisions in this particular guidance would apply to you about your employees in the common areas, and if they have symptoms. There's regulations about how often you have to clean touch surfaces, where you have to have hand sanitizer available for your employees. So if you choose to open up the clubhouse, I think that the general business guidance is something you should review, and more likely than not, it's going to apply to you. And then what you'll do is you get into the industry-specific guidance. And I'll just pull out for an example. There's a page in the guidance related to fitness facilities and gyms. And the expectation is, and I've actually had a couple conversations with the health department, is that their expectation is, if that's the type of activity that's transpiring in your facility, you should comply with the industry-specific guidance. And we'll talk about that when we get to, like, for example, the gym facility, and I'll talk about how frequently are you supposed to be cleaning the free weights, for example. And so all of that is coming from the reopening plans, and they're going to change when we move from phase 1 into phase 2. So let's talk a little bit about just general compliance with the governor's orders and essentially the capacity limits for clubhouse. And this is really kind of fits into the definition of gathering and social distancing. So gathering, and I'll just read you the definition from the plan because I think it makes a lot of sense, is that gathering refers to the social setting where appropriate social distancing, i.e. the 6-foot separation, may not be practical, such as receptions, trade shows, and similar events. However, gathering limits do not apply to the number of people in a facility at any one time. For instance, a retail store may have more than 10 people and not be considered a gathering. So if you take that definition and you apply it to, for example, your clubhouse, we don't believe that you have to limit your clubhouse to only 10 people. But you have to be aware that there could be 10 people gathering in, say, for example, the pool room to play a game of cards. At that point, you have probably exceeded the gathering limitation, even though you may not have had a capacity limitation on the clubhouse. And so hopefully I've tried to explain that, in the best way possible, but we've been getting a lot of questions about which one of those applies. Do I have to keep it to 10 people? And by the way, I want to make sure you know, when we move into phase 2, that 10-person gathering becomes a 50-person gathering. So you have to be aware of that, because as we move forward into the future, the limitations are going to expand and we'll be able to do a little bit more. And then finally, I've got a lot of questions about face masks. Do people have to wear face masks if they go to the gym? Do they have to wear face masks all the time? And there are regulations specific for gyms about face masks. Phase 2, it lightens up a little bit about whether strenuous exercise you have to have a face mask. So what we would say is there is regulations. The ruling guide of thumb is when people are within 6 feet of each other, they should have their face masks on. If you have employees, there's a certain amount of regulations that communities can choose as to what activities those employees are doing when they interact with others as to whether they should have their face masks. So that's the general guidance from the enforcement that we're going to kind of pull from when we are asked questions. So I think that launches us into pools. So Stephanie, can you jump to my pool slide? All right. So pools directly. I've been talking about pools just about nonstop for 2 weeks. So we kind of put a lot of the categories into this slide that we can just talk generally about and give you some general guidance. And here's where Delaware and Maryland are going to have some differences. And we're probably expecting a lot of questions. So the question, can they open? Should they open? That's the question I'm getting all the time. And the health department has put out guidelines. I'm assuming most folks on this call have seen the guidelines. The guidelines that Delaware put out have changed several times, and they're fairly restrictive when it comes to the frequency of cleaning, and it places upon the community the association's obligation to enforce social distancing, and it puts capacity limits on, and the capacity limits are a fairly difficult calculation based upon the square footage of your pool or the square footage of the deck around the pool. And so these are all things that you can pull from the regulations. So to answer that question, can we open? Should we open? Well, in Delaware, we answer the question, yes, you can open. Open goes all the way back to that risk cost benefit analysis. What's it going to cost to comply? And can I get insurance? Do I have insurance? What are my risks? So that answers that question. Yeah, you can do it. Now start to undertake the analysis. Some of the other questions we get, well, what about the furniture? If people, if I now have an obligation to clean the facilities, can I remove furniture and make people bring their own furniture? And the health regulations do not address furniture. It doesn't require you to have it there. So I have a number of communities that are choosing to remove their furniture because of the difficulty in cleaning it. I have some communities that are leaving the furniture there and implementing the cleaning regimen. It really is going to apply to what is your facility and what is the nature of the furniture that you have. Pool cleaning. So for the Delaware regulations, it's an interesting. High-touch surfaces are every 15 minutes to a 2 level, but that changes a little bit based upon of the other surfaces, and they're outlined here in the regulations. So I would encourage each community to look at the regulations if they're going to open and determine how are we going to clean. You have to use EPA approved disinfectants. There's the time frame. The question is who is going to do it, because what we're learning is the lifeguard companies don't believe the lifeguards should be cleaning because their focus is on actually lifeguarding. So those are the types of things you should look at the regulations and deal with them. Lap swim is addressed in the regulations also. It requires that the lanes be 6 feet apart from each other, and it limits the number of people using lap lanes to 2, so you can do lap swim. You just have to make sure you follow the regulations. What if you want to just not open the pool? Do you have to drain it? That's one of the other questions that we have seen. And what we've been advising folks is there actually are some jurisdictions issuing guidance on what you expect, what the expected regulations would be to not drain the pool, but to keep water in it and to keep treating it. So for example, Worcester County, which is Ocean City, Maryland, issued regulations setting the pH level that if you're going to keep your pool closed to the constituents, but it still has water in it. What pH level do you have to maintain it at, and how frequently does it have to be cleaned? So they're, not opening the pool doesn't mean you can just ignore it. You do still have to deal with that type of thing. And then lastly, we're being asked an awful lot of questions about waivers. Are they enforceable? Should we get them? So our general advice, and by the way, this does change by jurisdiction, is that in Delaware and Maryland, waivers can be enforceable, but we want people to know it is not the silver bullet to prevent all issues of liability. Having waivers doesn't stop you from getting sued. Courts oftentimes will not enforce waivers if the language is not clear and it wasn't clear what people were waiving. So what we say is they are a tool, they have benefit, but you shouldn't look at them as the end-all, be-all. So that's Delaware and Maryland. For example, Virginia, we know waivers aren't enforceable at all, so there's really no point in getting them. And then if you as a community start to think, do we want to get waivers? Some of the things you have to think about is, okay, how are we going to enforce it? How are we going to have people do it? What happens when some people refuse to sign the waiver? Who has to sign the waiver? Is it all adults? What do you do with minor children? So there's a number of things to think about when you go down the route of waivers. So we're happy to kind of talk about them generally. And I would say I have a number of clients that have chosen to draft waivers and demand that their constituents sign the waivers. And I have a number of communities that have figured that getting the waiver is just not worth the hassle. So that's really kind of it on pools. Tiffany, did I miss anything you want to throw in there for Maryland?
Yeah, so just to throw in for Maryland, first to piggyback on what you said about waivers, I also want to put it out there to everyone that, like Chad said, like that's going to be a business decision whether you get them or not, because of Maryland, Delaware, D.C. Typically waivers are enforceable. But I think what we all have to keep in mind here is that we are in an unprecedented time. Never has a court probably had a case that's going to come before us with coronavirus issues. So let's say you get sued with that sort of issue and you have a waiver, this is all going to be new charter territory for the courts in deciding on those issues that are going to come before us. So it, typically with waivers, we may have some idea of some precedent of how courts have treated them with regard to certain issues in the past. Because of the pandemic that we're in now, and this is uncharted territory, we don't know how a court is going to treat a waiver in the future. With regard to Maryland and pools, just want to reiterate what Chad said. So Maryland's order did allow public swimming pools to open. But what you have to keep in mind is that Maryland also delegated a lot of that, saying it's subject to your local regulations and orders. So if you are in a different, for example, Prince George's or Montgomery County, those are the two counties that have the first and second highest number of coronavirus cases. Their county executives have specifically put out orders saying the pools are not going to be opening as of right now. They're not part of that phase one. So you need to make sure that you are looking at not only your state-specific order, but if you're in Maryland, you need to look at your local county order to see if there are any sort of restrictions. And that's restrictions with regard to opening, and also if there are any guidance or restrictions on cleaning. I don't know about Prince George's County, but I know Montgomery County that they are putting regulations together that address what Chad had mentioned, where if you decide not to open the pool, there's still cleaning regulations that you're going to have to adhere to if your pool remains closed. So you want to keep a lookout for those sorts of things. And also, as always, the CDC has a wealth of information on a lot of these topics. So make sure that in addition to looking at federal, state, and local regs, look to the CDC for some of their guidance on cleaning and other precautions that you need to be taking if you're going to open your pool.
And let me jump into, because I see one of the questions in the chat box is relevant to the pool discussion. Let me just read the question. Can you discuss whether a sign saying users of these facilities accept all COVID-19 risks absolves the board of responsibility if someone claims infection was caused by exposure to the pool or the tennis courts? So let me take that question now, and to remind you that actually there is a affirmative duty to put signage up. The pool regulations actually require it, and it has a link to the CDC or which signs you put up. So yes, you have to put these types of signs up. But I think the question was really geared toward, does putting a sign up have the same benefit as actually having an owner sign a waiver? And I would, and I've taken the liberty to modify that question a little bit, but it does not in my mind. So the sign will give you some benefit. And the concept is it's a contributory or a comparative negligence, which is and someone must know in today's day and age with COVID that when you choose to go to the pool, you're exposing yourself to more risk than you're staying at home. So that's an assumption of certain risks that you are somewhat negligent yourself in going, and the sign is putting you on notice of that. So it does have benefit, and that's why the sign requirement is there. But the waiver takes it even a step further in that not only did you know about it, but you're choosing to voluntarily waive your ability to file a claim should you become infected. So the signs are great. Yes, do it. Waivers add a little bit more on top of that. So hopefully I've answered that question adequately for folks. And I think that brings us to the next slide, unless Tiffany had anything else you wanted to throw out on pools. All right, Stephanie, can you move us to the next slide? Great, thank you. Tiffany, I think I dumped this one on you.
Yeah, this is fun. So the Clubhouse, this is just some of the common questions or considerations we have talked with our clients about. Chad mentioned early on in the presentation about the capacity versus gathering argument. I can tell you the Maryland order is not clear on, when you talk about limiting gatherings to no more than 10 people, it doesn't specifically define really what that means. So that's one of the things that you got to keep in mind. What is capacity versus gathering? Does it mean the capacity is 10 people total in general? Or does it mean that there can be a family of 5 here, a family of 5 somewhere else, the staff somewhere else? You need to keep those considerations in mind with regard to your clubhouse. Looking at how often cleaning is required, keeping that in consideration, looking at your local ordinances, state orders, but also the CDC guidelines are a great tool there. You want to be cleaning probably more frequently than you have been in the past, because again, if they're high touch surface areas, the CDC is very clear that you need to be cleaning those more frequently to help limit transmission of COVID. And then another question we have gotten is a professional cleaning company required? The answer to this is no. A professional cleaning company is not required but you do have a duty to do some sort of cleaning. So if your staff, maybe your contracted out staff or your in-house staff can do the cleaning and make sure it's adequate and it's done properly, you don't need to have a professional cleaning company. Again, you can use your current staff. I know we've also gotten some questions about using volunteers. Be careful with regard to using volunteers, because you need to make sure that those volunteers are going to be not only reliable and actually show up and do the cleaning at the times required, but that they're also going to do an adequate job in doing the cleaning. So their performance is going to be another issue you need to keep in consideration. This is why most people may rely on your staff, because those are the people that get paid to do it. It's part of their job description, so you may have better results that way. But these are some common considerations to keep into account. Let me be clear, though. Chad will talk about Delaware, but with regard to Maryland, the way the governor's order reads, clubhouses, we have interpreted as clubhouses are not ready or authorized for opening as of yet. Because of the language in the order limiting gatherings to no more than 10 people, and because it doesn't provide a whole lot of guidance on that, we have been telling our clients keep the clubhouses closed for now. Chad, I'll throw it to you to talk about the Delaware issues.
Yeah, so on clubhouses, we have not interpreted the guidelines as requiring them to close, but I can tell you the vast majority of communities have been choosing to keep them closed up until now. And so now that we've gotten to phase 1, the regulations for phase 1 are more broad and would allow the clubhouses to open under those guidelines. All right, so I think that takes care of clubhouses, right? Was there any other questions on clubhouses? I think we covered the ones that were cleaning. So that brings us to the next slide, which is fitness centers. We put together a couple questions. Some of the questions related on fitness centers: does it have to reopen, right? Meaning, does the association have an obligation to reopen it? And I think the answer is no. You still don't have an obligation to reopen it, but under the guidelines, as you roll into phase 1, fitness centers and gyms are allowed to reopen, so the association may choose to once they go through the risk and the benefit analysis. Well, how often does it have to be cleaned? and does it have to be cleaned by a professional? And that's where, for Delaware, I am relying upon the guidance put out for exercise facilities. And I'll just read you some of the things that's required. That the exercise equipment has to be staggered at least 6 feet. Classes are not allowed, but if you do, you have to have socially distanced and limited. People have to bring their own yoga mats. The one that really catches people is that there has to be a regular cleaning of all equipment between uses. That includes free weights. So each time somebody uses a free weight, it has to be cleaned before it can be used by somebody else. So there's a number of regulations in here that go to how often the cleaning has to be done and what the products are. And so if you choose to open, the expectation would be that you would strive to comply with the guidelines that are put out by the state's office. Are masks required? So masks are required under the phase 1, and I've seen that in phase 2, the language related to masks does allow that if strenuous exercise is being conducted, masks can be excluded. And I think it was within, so long as you were not within like 10 feet of someone. I can go back and take a look at that. But so what you want to do is be paying attention. These regulations are changing all the time, as you might imagine. So this has happened to me once before, whereas I was given advice based upon what the regulations were on Friday, but then by Monday they had changed. So these are the things that you want to check on and check from time to time, just to make sure that what you're requiring as to masks, for example, on treadmills, is consistent with the regulations being put out at the present time. So that's kind of it for fitness centers. I think that brings us to the next slide.
And Chad, can I just add, this is Tiffany.
Sure.
For Maryland, I mean, the Maryland order is specific about fitness centers right now. In phase 1, they're not open. The only exception is that if there's a fitness center where there is a daycare facility also located in the fitness center, and so the daycare center may be operational for essential employees, then they can have the fitness center open because if it's being used by the daycare center. But in general, both many county, at least I know Montgomery and Prince George's County, in the state's order that the fitness centers are not open at this point in time.
Excellent. Is that also for outdoor exercise facilities too, like basketball courts, like venues like that?
So that's a good question. Basketball courts and pools, no, as of yet, but there are certain other outdoor activities that are permissible at this point in time, such as golf. So if you're in a community that has a golf courses and driving ranges can be opened, outdoor archery, shooting ranges, campgrounds, horseback riding, those types of things. But typically speaking, and some outdoor swimming pools again, but when you're looking at pools, you got to go look at your local regulation, not just the state regulation. So yes, there's some outdoor activities that are permitted, but there are also some that are not.
Okay. I think the next slide is yours. Were you going to take management offices? Sure.
Yep. So management offices, some of the considerations that you want to think about with regard to opening, and some of you all, I know that in Maryland, we have taken the position that community associations are essential business. So a lot of our management offices did not necessarily close down. They just limited some things and put further restrictions in place to protect the staff that were working in those offices on a daily basis. But most management offices, I mean, if you're in Maryland, we deem it to be an essential business, so you can reopen, or you may not have ever closed. You need to look at what services is being provided by the management office. When does it have to be reopened if it closed? And also, can it be restricted? And the answer to these questions are all going to depend on the level of service and access by your residents to the management office. I know that I have one large community in Prince George's County whereby the office has remained open during COVID, but residents cannot physically come into the office. So they have to communicate by other means in order to protect the staff. That is a restriction you could still put in place. The Maryland order with regard to any establishment coming in, for the most part, somebody would have to have a mask or the proper face covering if you're allowing them to come into your management office. Even though we're allowed to reopen certain facilities, we also have to keep in mind that reopen doesn't mean that everything goes back to 100% normal in the way it was before. So you may have to limit certain services because you still can't do things you were doing before as a result of state and local orders. So keep that in mind when looking at the management office.
Okay, and I think the next slide is playgrounds and sports courts, which we got into just a little bit earlier. But the way I've been addressing that is, what is the activity? So you really got to focus on each activity, because you can't lump everything together. And so, for example, the Parks and Recreation Guideline from the state of Delaware allow certain outdoor activities to reopen and to continue, but it does limit those that cannot actually be performed where social distancing can be maintained. It uses an example, basketball courts and playgrounds. So, for example, what I was saying, and it goes on to give an example that the tot lots or the playground, the expectation is you're cleaning it between each person's use, which is really just not practical. So that's why some of those things are needing to stay closed. Basketball, as you might imagine, is one of those close sports, but if it's just one person that's doing the activity, that's fine too. So you have to start to get into the analysis of each of the activities. Can I perform the activity while still social distancing, and can we do the cleaning that's appropriate? So some of your activities, maybe. I know that the National Tennis Association and the Pickleball Association have all put out regulations about whether you can perform those games socially distanced and what some of the best practices are. So I throw it back to the community to say, you have to make sure that if your activity can be done socially distanced, you can consider reopening some of those sports activities, and just you got to comply with the regulations. And I think, jumping ahead, that brings us to the next slide, board meetings, when then we'll talk about annual meetings also. And as you might imagine, I know that my last 2 weeks I've been talking about pools, clubhouses, and everything. But prior to that, I spent the other 2 weeks talking about board meetings and how to shift to electronic meetings. So I thought we might as well just throw this in here, because we may have a question or two about it. So board meetings, can they be virtual? And I'm going to answer for Delaware first, because Delaware is actually quite easy to answer the question. Delaware has always allowed electronic meetings, meaning to be present at a meeting in Delaware, you only have to be able to hear and to be heard. So you could have done telephone meetings in the past, you could have done video meetings in the past, you're allowed to vote electronically. So that has always existed. The problem being, it just takes an awful lot of coordination. So it's a lot easier just to throw everybody in a room and do a regular meeting. So as to Delaware, yeah, you can pivot to a virtual meetings. It just takes a lot of planning ahead of time. And I know Maryland's going to be a little different, and I'll let Tiffany jump in on that in a second, but let me just hit some of these other comments. Do you still have to allow the owner comment? Yeah. To be present at a meeting, all you have to do is hear and be heard. And some of these electronic platforms allow, just like this platform here, the moderator can mute you if they don't want you to speak, and then when it's your turn to speak, you can raise your hand or move forward. And one of the other questions we get is, well, if we choose to still have our meeting in person, what liability do we have if people get sick? And I don't think that analysis is any different than what we've been talking about before. If you can't do this socially distanced, then technically you're having a gathering, and so you can't have a gathering of more than 10 people right now in Delaware. So you can only do your meeting and have 10 or less people. So yeah, there is potential liability there. I've had a number of communities that are starting to pivot to a combination of some people in person and everybody else electronically. So that's one of the things that's been going on. So Tiffany, anything you want to jump on Maryland? Because I know there's some differences now.
Yeah, for Maryland, the board meetings are pretty much the same, because the Condo Act and the HOA Act do allow boards to meet electronically for the most part. And again, you want to look at your local regs and also your governing documents. Board meetings are not the bigger issue in Maryland. I think it's the annual meeting, which is on our next slide that we're going to get into, and I'll give more specifics at that point. But you just want to make sure for board meetings in Maryland, if you're doing them either teleconference, Zoom, Skype, electronic, video, that you are providing the greatest access possible to everyone who wants to attend, because the statutes require that individuals be able to attend and be able to hear and listen in to what the board is discussing. So sometimes in older communities, you may have individuals that do not have access to computers. So if you're using a Zoom option, you want to make sure there's also a telephone option for Zoom if I can't log into Zoom through a computer. Or if you're using Microsoft Teams or something else, that there's a telephone option so that members can participate and listen into those board meetings.
Okay, and then we'll jump over to the next slide, which is annual meetings. And just to make sure everyone on the call recognizes the distinction is, the board meeting is for the board to conduct business, but under both Maryland and Delaware, your owners have a right to observe and participate in that meeting at some point, but mainly just to observe. But the annual meeting is for the members to conduct business. And typically in that process, you are doing your elections or the adoption of the budget. And so annual meetings of members under Delaware law can also be virtual, as long as you can hear and be heard. Now, how do we put 500 people into a video call? It definitely has its problems, but it's not an impossibility. So it's easy for us to say, can it happen? Yes, us lawyers say, go ahead, do it. And then it falls on the poor property management company to figure out how to do it, get everybody registered. The issue is, well, how do we vote? Are we actually going to take hand votes or voice votes, or are we going to incorporate some sort of electronic voting system that everyone can use? There's plenty of platforms out there that allow that process to occur. It just takes an awful lot of pre-planning. So it was very difficult in those first weeks of COVID to pivot to this, but I think that people are learning and finding that there is a way to make this happen. And the questions we get is, well, can we prevent nominations from the floor? And that type of question we always go back to and say, I don't think COVID changes that. If you were allowed to do nominations from the floor before, you can still do it. You just have to find a way to make it work with your technology. So that's how I have. That's primarily the Delaware answer, and I know that we've got a little bit of a different answer from Maryland. So Tiffany.
Right. For Maryland, for the most part, it does follow what Chad said. But the challenges we have faced in Maryland is that for some communities that did annual meetings or tried to hold them early on when COVID first started, there was some pushback from the Attorney General's office in Maryland with regard to the process they were following. The Condo Act and the HOA Act allow owners to vote electronically. The question is, how are you allowing for that? And how are you also allowing for nominations from the floor? And the nominations from the floor were of great concern to the Attorney General. So one of the options we came up with, or we've discussed with clients, is that if you're going to do electronic voting, I strongly recommend that you use an actual company to coordinate that with. Let me be clear, there's differences between electronic voting. Some people define electronic voting as I fill out a proxy or fill out a ballot and I email it over to the management company or the management office. Then you have the true electronic voting, which is I may do a proxy ahead of time, but for the true electronic voting, if I'm actually attending the meeting, I am given a website and an ID number where I actually log on to a website and do my voting that way. That's that true electronic voting. So the question became, in either scenario, there was an issue with nominations from the floor, and how do you account for that if I've already voted electronically? And so one of the things the AG said is that they would deem a meeting to be sufficient or meet the requirements of the law if the person allowed, let's say you have a Vote Now system or HOA Act, those are two companies I know that do the electronic voting, where they allow you to vote, but then you also allow for paper ballots for a certain period of time after the meeting before the election results are released. This would allow for, so that if I voted already, there are nominations from the floor, and maybe I wasn't on the actual virtual meeting and I want to change my vote somehow, then if you allow that 48 hours or 24 hours, however you determine after the meeting, to allow people to change their votes to recognize those people nominated from the floor, then the AG's office has provided guidance saying that that would be sufficient to meet those annual meeting requirements. But that was one of the main concerns. The other thing is that the AG's office has been clear that we all recognize that there really can't be an in-person meeting. And the reason why is because in addition to, let's say you can't limit the gathering to no more than 10 people, even if that was lifted to say it has to be no more than 50 people, the concern that we have is that nobody can tell an owner that they can't come into an annual meeting. So physically, we cannot turn people away. So the AG's office has recognized that difficulty and said that there shall be no in-person meetings until everything is lifted. And so your default is going to be to do it virtually.
Okay, so I think that brings us to the next slide, which is questions. So let me take a shot. I think I saw one or two here in the chat box that I'll take a shot at. And then probably I guess Stephanie would probably then open it up. And what I would ask you to do is, when you do ask questions, tell us what jurisdiction it is so that Tiffany and I know which one of us should jump in. So here's one of the questions. If the community pool membership is included in your association fees and the pool is closed due to COVID, are the members entitled to any type of refund? So when we answer these kind of questions, we always say, well, the starting point for answering that question is going to your governing documents to see if your governing documents address it. I would be surprised if they do, but who knows? Maybe something like that is in there that entitles owners to refunds if certain amenities are not available. But if it's not, and your documents are silent on that task, we would be I would be of the opinion that the governing board has the power to collect assessments for the common expenses. And so if you still have common expenses that you have to pay for, then owners would not be entitled to a refund. Now, if the expenses have dropped and there's a surplus at the end of the year, Delaware statute does address an obligation for an association to return surpluses or to credit it to future. So it really all depends on your governing document language and whether or not you're going to have a surplus at the end of the year. So that's how I would answer it under Delaware. Tiffany, anything different in Maryland?
No, I think that's the same. I mean, the first thing you're going to look at is what do your governing documents say about that. I'm also one of the people who have to look at, do you even have a way to parse out what the funds are for certain amenities? Because while you may have a pool contract, there may be other amenities. Let's say you close the playgrounds or something else. Is somebody going to come back and say, well, I want a refund for whatever portion of the money is spent maintaining the playgrounds? And you may not have it broken down that way that you could figure out what amount of money should be refunded for maintaining the playground since they're not open. So just keep those sorts of things in consideration. But I agree with Chad, you need to look at your governing documents and then look at the state statutes in your area to determine if it's even possible.
Okay, one of the other questions from the chat box relates to open meetings. It says, we're a newly formed board. We've been holding Zoom calls up to 3 times a week. Should the homeowners be allowed to attend these meetings? So in Delaware, there's a few exceptions. There's always an exception to the rule that old pre-2009 HOAs sometimes get away from the open meeting requirement. But generally, most of your community associations in Delaware and Maryland have a requirement that board meetings be open to the public except for executive sessions. And there's a list of topics in the statute of the types of things that you can go into executive session for to exclude. That's generally, so generally, yes, obviously, but for each community, you're going to look at your governing documents and get a specific example as to your community and what applies to you, depending on which state it is. Tiffany, did I miss anything on that?
No, the only thing that I would add, Chad, is you have got to be very careful with this because the whole intent behind open meetings is transparency. And it's the whole idea that the members of the community should be able to observe the board in action and know what's going on. I am always concerned when I hear, and I understand with new boards because they don't know yet, but I'm always concerned that if you start off doing this and owners get wind of it, the owners always tend to drive or go to the negative and thinking that the board is hiding things and that the board's being non-transparent because they're not opening the meetings and the board's meeting 3 times a week. So you want to make sure that you're limiting that to the extent possible. Maryland law is very specific about you have to put out a schedule of when your meetings are going to be. And the owners have to get a certain amount of notice of those scheduled meetings. So you want to try and adhere to that as much as possible. And further, if you are in certain counties, Montgomery County to be specific, anytime a quorum of the board is meeting, even if you got together at a bar and we're doing something, they will deem that to be a meeting of the board. So you have to be careful about these things where, yes, it may be a quick call to discuss something, but in certain jurisdictions, they will still see that as a meeting of the board and say, you didn't put out any information and you didn't notify the community of this meeting, even if you're not specifically voting on something. So just keep that in mind.
Okay, so I think at that point we'll open it up. I see a couple other questions in the chat, but I guess what we'll do is open it up for questions now, and if there aren't any, then I'll double back on maybe these 2 that are still in the chat box because they're not necessarily COVID questions.
So if anyone has a question, please, like Chad had advised, please let us know where you're located so they can best answer it. If you're having your need to unmute yourself and you're on the phone, it's *6. If you're on the video, there's the unmute button at the bottom. We would love to hear your questions.
And while we're waiting, Chad, I can address this one that just came in, that I can address it as far as Maryland. There's a question that just came in about, are email exchanges between board members considered a meeting of the board? So typically in Maryland, yes, that can be considered a meeting, and what it would be considered is a closed meeting of the board, because it's not an open meeting. I know that in Montgomery County specifically, they have issued guidance on this and said that that would be considered a closed meeting. I further always encourage my boards, avoid the email transmissions except in cases of emergencies, because all that stuff is discoverable, and you want to make sure that you're having these discussions in an open meeting and not offline in what would be considered a closed meeting.
So I guess while we're waiting for questions to come in, I'll take a shot
I
at
was
the
just
question.
trying to ask, I guess my mic was still off. Does that same response hold true for Delaware in terms of the emails?
Okay, so Delaware's jurisprudence, case law, is not as well developed as Maryland. So we don't have court guidance on it. So I'm telling, when I answer that question, I tell folks, this is what I think the court would do. And I believe the court would conclude, like Maryland has, that emails, so if you put an email together that has all the board members on it and you discuss back and forth a topic and reach a decision, you have held a meeting without proper notice. So I think that what Tiffany has says is my opinion, when asked to a Delaware court, would come to the same conclusion.
Great question. Is there any other questions before we circle back on the chat questions? Okay, so it looks like we have some chat questions.
Yeah, so the first chat question, I'll take it for Delaware, since we don't know which jurisdiction it is, and we'll take it. So the question is, should a board keep vendor quotes secure and not published? And I would assume that we consider sensitive information. So the Delaware statute allows for the withholding of unexecuted content, and it allows a board to go into executive session to talk about unexecuted content for the purpose of protecting that competitive environment. But once the decision has been made to award a contract and the contract is signed, it becomes part of the books and records of the association. Only during that negotiating period where you don't want the terms to get out from one vendor to another, that it can be protected. That's the Delaware answer.
And the Maryland answer would be the same. Both the Maryland Condominium Act and the HOA Act allow the board to discuss in closed session and withhold from some records any sort of contracts that are currently in negotiation, for the exact reason that Chad said.
All right.
I think I also saw one. I don't know if the person is still online, if they're able to put some more clarification in, but there is a question about HIPAA and what role that plays. I don't know if they're able to put more information in here. I assume they're talking about with relation to the pools or the common amenities. Let me just be clear. HIPAA in general, one of the common confusions with HIPAA is who HIPAA covers. HIPAA laws typically cover healthcare providers, clearinghouses or organizations, and their release of medical information without the authorization of the actual individual that's the subject of those records. Usually it's not going to apply to a community association, but privacy laws will apply to a community association. In addition, if you have staff and you have confidential medical information about staff, there are privacy laws related to that. The same would be under the Fair Housing Act. There would be privacy laws regarding disclosure of medical issues related to residents. So while HIPAA may not be applicable, you would still have the same concerns under those other laws.
So Tiffany, if like a member of one of our communities ended up contracting COVID, they could not disclose who it was specifically, but could they disclose that someone in the community has it and so people are aware? What do you recommend in those situations?
So, and I'll let Chad chime in on this one. This has been a hot topic and a huge debate early on when COVID started, and I got a lot of pushback, myself and some of our other partners, because our recommendation is don't disclose. The reason why is because it depends, it depends on the size of your community. I may not disclose the specific name, but if I'm in a small community, somebody can determine who it is to begin with. And we took the position that it doesn't matter if somebody in the building has it. We need to be acting as if somebody in the building already has it. We should have already been doing precautions to prevent it. And the main problem with disclosing names is that you can disclose, if you disclose the name of a person, you've now set a precedent that every time you learn of a case, you're going to disclose it. Well, what happens if people are not revealing to you that they have tested positive for COVID? So you've now created this level of liability and a potential risk of liability for the association. So we took the position that you should not disclose if anybody in the building has contracted, because one, they don't have an obligation to tell you that. And instead, what you should tell people is you have to assume someone in the building has it. And as such, you need to take proper precautions to avoid the spread or transmission of the virus.
And the only thing that I would add to that is sometimes we're telling communities that if they get express permission from the person, they can disclose whatever that person tells them they can disclose. But what I'm finding is most of the time our communities suspect someone has it from a social media post or something along those lines. And what we're saying is that's really just not a verifiable source. Go to the source. If the source gives you permission to tell their neighbors, maybe they want their neighbors to know, maybe they need some help to do it, but to only do it after they get express permission to do so.
Great, thank you. Looks like a couple more questions came up in the chat, so we'll address a few more here. So it looks like we have our board many times during week go back and forth on operational needs and have to make decisions. It would be very difficult to provide advance notice every time we need an email exchange. It would seriously delay operational needs. How can an HOA operate efficiently if we have to provide such advance notice for regular operational task decisions? So I think this goes back to the email correspondence.
Mm-hmm. So Chad, I can address it. In Maryland, I get it. This is an unprecedented time, and you're absolutely correct that you have to make some quick decisions without having time to set up a meeting or anything. But what you need to make sure you're doing is, one, that is the exception, not the rule. Two, any decision that's made over email is not a board decision until it is ratified at a board meeting. Remember that your meeting minutes are the official documents of the board, and those reflect the business of the board. So you always have to keep the mindset that if we made a decision over email that we never ratified in the board meeting, it is as if the decision never happened. So for those emergency things or urgent matters that you have to tend to, especially in light of the pandemic, if you have to do it by email, you can do that, but you have to make sure that when you have your next regular board meeting, you are ratifying that decision that was done via email. Also, keep in mind that most documents say, you need to go back and look at your documents. Most documents say that if a decision is made outside of a board meeting, there needs to be unanimous consent. So if you are making a decision via email, all board members need to be in agreement with that decision. If they are not, you may need to call a special meeting of the board in order to discuss the issue and make a decision there.
And I'm not, this is Chad, I'm not going to change any of that for Delaware. And we deal with it very uniquely because an awful lot of my clients are resort communities. So people do not live in Sussex County, Delaware, or they don't live in Ocean City, Maryland, but the boards are there and they have to still conduct business. And so it's a balancing of that transparency and what you're supposed to do. But I will also say technology allows you to use the Zoom and the telephone, just let your owners call into it. It's the emails that get you in trouble.
Mm-hmm.
So that sounds like another topic that we can get into another day. You guys, we'll wrap up in a moment if that's okay. Looks like we just had a couple pool questions and then we can wrap up from there. So
Yep, yeah, and I can take that pool question about the small pool facilities, because I actually did call the health department on that particular case. I mean, and essentially I asked them, well, what do you mean? And I'll just read the smaller facility. This is all that's in the regulation. Smaller facilities can opt to monitor pool area and chemistry at least twice per day in lieu of staging staff at the pool, but must also reduce overall pool capacity to less than 10. So I read that phrase as allowing community pools to do two things differently, which is to not have a monitor on the pool deck at all hours of operation, and to reduce the testing of the chemicals from once an hour to twice a day. Those are the two things that you get if you want to be a small facility. What's a small facility is really what the question is. I called the health department, and their response was, well, we'll know it when we see it. I was like, great, yeah, that's really helpful. So what they said to me is, look, if it's a massively large pool with like a kiddie area and fountains and slides, that's not a small facility. But if it's a really small pool, then that's probably a small facility. That was their answer, so that's what I'm giving you. I've had a number of communities that say, well, ours is a small pool, and we're going to reduce it and not let more than 10 people go there. And that's your choice. Some communities, 10 people is adequate because not many people use the pool, and some communities, 10 just won't work. But that's the answer to that question. And I see one more pool question. It's a Maryland question. Did you see that one, Tiffany?
So it says,
Mm-hmm.
do you know if community pools in Maryland are considered public or private?
When you say community pool, so unless it is a public pool that is open to the general public, no, it would be a private pool. So a community pool could mean if I'm in a condominium that's part of a larger community association, but that pool is only to be accessed by the members of that association, including the condominium, no, that's still going to be a private facility. If it's a public pool where anybody in the public could pay for a membership, come in and use it, then it's a public facility.
And if I could add, make sure you check your local regulations. So, for example, in Worcester County, which is Ocean City, they have 3 categories. They have a semi-private category. So essentially, that's for the community association where not anybody can use it, but there's a lot of different people using it. So make sure you look for your jurisdiction about what permit you have to have. And by the way, while we're talking pools, it's my understanding in Maryland that there are some super strict pool requirements coming into play in September of this year. So they intentionally made it September so that you can get through this season without having to deal with it. But for next season, there's an awful lot of regulations. So you may want to have a vendor come out and take a look at your pool that requires certain heights on fences and no leaping off points. And sometimes those new regulations conflict with the ADA, meaning the safety requirements make it very difficult to access a facility that it may be a violation of the ADA. So I would just encourage all owners to at some point have their vendor take a look at the new regulations and make sure their pool doesn't need construction over the off season.
All right, excellent. Well, thank you, everyone. I know we went a little bit over time,